Have you ever made a promise, a deal that suddenly became impossible to keep because of something completely out of your hands? Well, we're about to dive into a really fascinating legal idea that deals with exactly that. It's called the doctrine of frustration, and it's all about what happens when the entire foundation of an agreement just disappears.
So let's just kick things off with a scenario. Imagine you've planned the event of this century. You've sold every single ticket, and then absolute disaster. The venue, the concert hall, it burns to the ground the night before. Now, your contract says you still owe the rent. Do you really have to pay? Is that fair? This exact kind of problem is where the law had to get creative.
All right, here's our game plan. First, we're going to look at the old super strict rule that just had to break. Then we'll explore what happens when the whole point of a contract disappears. We'll also get really clear on why just having a tough time doesn't count. After that, we'll see how the law cleans up the financial mess, and finally, we'll ask the big question: does this old doctrine still hold up in our crazy modern world?
Okay, let's start at the very beginning. Because to really get the doctrine of frustration, you have to understand the ironclad rule it replaced, a rule that valued certainty above pretty much everything else, even common sense sometimes.
You see, for hundreds of years, the law was brutally simple. A deal is a deal, period. If you promised to do something, you had to do it. It didn't matter if a hurricane wiped out your warehouse or some other catastrophe made it literally impossible. You were on the hook. Now, this gave commerce a ton of certainty, but man, it often came at the cost of basic fairness.
And then along came the case that started to chip away at that old rigid idea, Taylor v. Caldwell, all the way back in 1863. This is one of those landmark cases you learn about in law school, and it all began, appropriately enough, with a fire.
The facts of the case were almost identical to that question I asked at the start. A promoter hired a famous music hall for a whole series of concerts. But before a single note was played, the whole place burned to the ground. The promoter, understandably, sued for breach of contract. And this put the court in a real bind. Do they stick to the harsh old rule and punish the hall owner for an accident, or do they find a new, fairer way?
They chose to find a new way. And what they came up with is what we now call the doctrine of frustration. Basically, the court said that when the very thing a contract depends on, in this case the music hall, ceases to exist, and it's nobody's fault, then the contract itself just ends. It's like a legal escape hatch. It's the law recognizing that sometimes the world changes so dramatically that forcing people to stick to the original deal is just completely absurd.
Right, so it makes sense if the thing itself is destroyed. But what if you can still technically do what you promised, but the whole reason, the entire point of the contract, has just vanished into thin air? This is where the law gets even more interesting, all thanks to a sick king and a postponed royal party.
So check this out. We have two cases from the exact same event. King Edward VII's coronation got postponed because he fell ill. In the first case, Crell versus Henry, a guy rented a flat for the sole purpose of getting a good view of the procession. When it was canceled, the court said, yep, the contract is frustrated. The whole point was gone. But in the second case, Herne Bay, a man hired a boat to see the naval review and to cruise around the fleet. While the review was canceled, but he could still cruise around the fleet, since the purpose wasn't totally destroyed, the contract stood. See the difference?
Now, this brings us to a really, really important point. The doctrine of frustration is not some get-out-of-jail-free card. It's not for when a deal just becomes a bit harder or more expensive or less profitable than you thought it would be. The courts have set the bar for this extremely high. And this quote from a famous case called Davis Contractors just says it all. Lord Radcliffe made it perfectly clear. The law is not here to save you from a bad bargain or just a run of bad luck. For a contract to be frustrated, the situation has to change in a way that is absolutely fundamental. Let's look at that case. A construction company agreed to build 78 houses in 8 months for a set price. But then an unexpected labor shortage hit. It ended up taking them 22 months, and it cost them way more money. They argued the contract was frustrated. The court basically said, too bad. The job was still to build houses. It just became a much tougher, more expensive job. And that, my friends, is not frustration.
So let's say a contract is frustrated. It just stops right there. But that creates a whole new headache. How do you sort out the money? Who has to pay for the work that's already been done? Who gets their deposit back? It can get messy.
Well, the original rule was really blunt. The loss lies where it falls. Whatever money had been paid, stayed paid. Whatever work was done, you ate the cost. It was a harsh all-or-nothing system. People realized this was often deeply unfair, so Parliament stepped in with a new law in 1943. This new act basically gave the courts the power to hit pause and do what's fair, to equitably share the losses between the two parties.
And you can see this new fair approach in action. There was a great case involving a Guns N' Roses concert that got canceled because the stadium was found to be unsafe. The promoters had already paid the band almost $500,000 up front. Under the old rules, that money might have been gone. But using the 1943 Act, the judge had the power to look at the whole situation and ordered the full amount to be returned. It shows how the law can now aim for a just result instead of just blindly following a rigid rule.
Which brings us all the way to today. You know, in our world of pandemics, global supply chain chaos, and massive political shifts, you have to wonder, how does this very old legal idea even hold up?
Well, we got a huge modern test case with one of the biggest political earthquakes in recent memory, Brexit. The European Medicines Agency had a 25-year lease on their massive headquarters in London. When Brexit happened, they argued, hey, we're a European agency. We have to be in the EU. Being forced to move is a massive, unforeseen event that frustrates the entire purpose of this very long, very expensive lease.
But the High Court said no, and their reasoning really hammers home just how high that bar for frustration is. The judge pointed out that, hey, the lease never said the UK had to be in the EU. The agency could still legally use the building and, this is the big one, they had the right to rent it out to someone else. Sure, Brexit made the lease a huge headache for them, but it didn't make it legally impossible or radically different, and that's the test.
And that leaves us with this big, final question. The doctrine of frustration is a crucial safety valve for when things go catastrophically, unpredictably wrong. But cases like the Brexit one show that it is incredibly hard to prove. So in a world that feels more unpredictable than ever, is that high bar still the right approach, or does it leave people unfairly trapped in deals that just don't make sense anymore? That's a debate that's still very much alive in the law today.